Thank you, Mr. Chairman. Let me start by echoing the remarks of my colleague, the senior senator from Texas, about universal injunctions, and to note in particular, Professor Fitzpatrick, as you referenced, that Justice Thomas in the so-called travel ban case wrote a concurrence there that I think was a very important opinion. And I think as a result of Justice Thomas's opinion, I would fully expect competent lawyers for litigants dealing with injunctive relief and dealing with plaintiffs seeking universal injunctions to raise those issues, and I fully expect that the lower courts and the courts of appeals and ultimately the Supreme Court will have to confront that question. But I think Justice Thomas's opinion rightly focuses on the impropriety of a district judge engaging in nationwide policy making rather than simply adjudicating a case in controversy between actual litigants before that judge. Let's shift, as we have been for most of this hearing, to the Ninth Circuit. Professor Fitzpatrick, it's been discussed at some length that the Ninth Circuit accounts for nearly a third of all pending appeals. And it takes an average of 13 months in the Ninth Circuit to decide a case, which is the longest of any circuit, and almost 5 months more than the national median. To what extent do you attribute this backlog and the delay in decisions in the Ninth Circuit to the very large size of the Ninth Circuit?
Well, I think there's a direct correlation, and I think if you even look more broadly around the country, you'll see the biggest circuits tend to have the biggest backlogs. It's just a matter of administrative difficulty to handle that many cases. And, you know, part of the difficulty comes from the fact you've got so many three-judge panels on the Ninth Circuit with so many cases that half of the job is keeping up with what the other panels are doing. And it's very difficult to do that, and the Ninth Circuit ends up with a lot of what we call intra-circuit splits, where different panels of the Ninth Circuit had decided the same question differently. And so that leads to a whole bunch of additional litigation to figure out which panel is the one that should be followed and which one shouldn't be followed. And so I just think that it's pretty obvious that when you have that many people running around, it's just hard to keep track of everyone.
Well, and of course, that goes right to the heart of the purpose of the circuit court system, to ensure uniformity of rules of law, that people can know and plan and behave accordingly. Judge O'Scanlan, you've served on the Ninth Circuit a long time. As a practical matter, what challenges are raised by its size? And in your judgment, how would it operate better if it were a size more commensurate with the other circuits?
Well, the biggest problem on that issue is the state of California being such a single center. State of California accounts for 70% of all the cases. One state accounts for 70% of all the cases of 9 states. And I suppose to directly answer your question, the problem is best highlighted by what Professor Fitzpatrick said. Intra-circuit conflicts are the biggest problem. In any given month, we would have 9 separate panels sitting together. If you can imagine that, 9 three-judge panels sitting. One panel in Honolulu, 4 panels, let's say in Pasadena, 2 or 3 in San Francisco, 1 in Portland, 1 in Seattle, and 1 in Anchorage. We really tried to make it work, but when you have that many panels sitting at the same time, sometimes there are issues that are on different panels which are really the same issue, and the results can be inconsistent. These are what we call intra-circuit conflicts. The national system is built to resolve inter-circuit conflicts, because it's quite possible that the Second Circuit would come up with a different response than, let's say, the 10th Circuit on a particular issue. But that is not something that should be allowed to happen within a circuit. But because of our size, that happens regretfully, happens too often. We do our best to try to deal with it by calling cases in bank. Sometimes they don't get enough judges who agree to take it in bank, and the intra-circuit conflict continues. But that would be a very important aspect.
And one final question, Professor Fitzpatrick. There have been some discussion that this issue of dividing the Ninth Circuit is driven by some of the recent decisions, either by district courts or the Ninth Circuits, that have ruled against the Trump administration. Now, the Ninth Circuit has for a long time had, I think, a well-deserved reputation of being far to the left, and the most reverse circuit. Indeed, I remember back in the mid-'90s when I was clerking at the Supreme Court, there was a running joke that there was a macro in WordPerfect for drafting an opinion that would automatically populate the opinion with the words, "The decision below was issued by the Ninth Circuit. Accordingly, we reverse." And the reason for that joke is the frequency with which that was in fact the case, and in fact the frequency with which the Ninth Circuit was reversed unanimously. And I would note one of the greater predictors of a reversal was a Judge O'Scanlan dissent, which often was a canary in a coal mine. But my question, Professor Fitzpatrick, is there any reason why breaking up the Ninth Circuit should be a partisan issue? For those on the Democratic side of the aisle who may be fans of the decisions of the more liberal judges on the Ninth Circuit, nobody's talking about removing them from the bench or they're losing the ability to adjudicate cases or anything else. We're talking about simply, is there any reason this has to be a partisan divide?
Well, Senator, I remember that macro very well. It was Control-N on my computer. But, Senator, I think the only reason not to split the Ninth Circuit is partisan. We've been talking about it for 40 years, well before there were any cases against the Trump administration. Every time another circuit has gotten this big, it's been split. I think the only reason we haven't split this one is because some members of this body want to keep the Democratic majority of the Ninth Circuit exercising its power over the biggest portion of the country as possible. So I think all of the intellectual, fair-minded reasons are on the side of splitting it. The only reason not to is partisan.
Thank you.